Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law, and I want to talk a little bit about timetables, more specifically the 6-month waiting period. A lot of people call up and they say, well, I hear there's a 6 months separation required or something like that. It shows a profound misunderstanding of what that is. There is a 6-month period during which, if there's a divorce with children, the court will calendar things over a period of approximately 6 months in order to let certain things happen. Yes, you can look at it as a waiting period, a cooling off period, you can call it all sorts of names. But the fact of the matter is, even if we call it nothing, when you have a divorce with children and there might be a referral to the front of the court, there might have to be a recommendation after an investigation for custody, parenting time, child support, a lot of issues relating to the kids. In those circumstances, even if there was no waiting period, the life cycle of that case may well be 6 months anyway, just because of the amount of time it takes to do things within the court. Look at it this way. If you file a complaint and you serve it on somebody, if they're in town, they got 21 days to answer. That already kills most of a month. If they're out of town, it's 28 days. So you can't really, short circuit these things and get them done a whole lot quicker. There is a 6-month waiting period. That's what I call it, for divorces with children. It's basically designed to allow the court to calendar things over a period of time so that it might be concluded at its earliest in 6 months. Now, can it be waived? Sometimes the courts will waive it. If everything's done and the court believes that it's in the best interest, particularly of the children, to go quicker, to bring finality to the case, then yes, the court can entertain a motion to waive the 6 months. Sometimes the court will waive it outright and conclude the thing before 6 months. A lot of times the court will allow you to proceed with the final taking of the final proofs and have the final hearing before 6 months, but not sign the divorce until the 181st day, right after the 6 months. So there's different ways to do it, but the short answer is the court can sometimes, at its discretion, let the parties go earlier. If they find that there's no possibility of reconciliation, like let's say the parties have been separated for years, that kind of thing, and the court doesn't really entertain a notion that they're ever getting back together again, that might contribute to the courts figuring, waiving the 6-month period will be of no consequence in a particular case. If you have any questions about that, reach out. We'll be glad to help you out.